rise.
Yes, Mr. Collins.
My Lord, I was going to go on to my next topic, which is the question of legitimate aim.
Yes.
And there were two aims identified by the EAT, paragraph 114 for your note. The first being the aim of maintaining the distinction adopted by the legislation between those who are workers and those who are not. And the second being the aim of protecting the rights and well-being of children in foster care. And there's no real dispute that the protection of the rights and well-being of children is a legitimate aim. There's an issue about rational connection. I'll deal with that in due course. As to the aim of maintaining the distinction in the legislation between those who are workers, that is, those who work under a contract, and those who are not, there is Strasbourg authority which makes it clear that an aim of this sort is legitimate, and that's Manole. I'll ask the court to turn that up, please. It's bundle 4. Tab 95. My lords may recall this is a case about a group of farmers who wanted to register a trade union, but Romanian law provided that only employees and civil servants could set up trade unions. It's just a very short paragraph I asked the court to look at on page 2970. Right at the top of the page, the court found that the interference with the right to register the union was prescribed by law. And then at paragraph 65, they looked at legitimate aim and said that the court further considers that the interference pursued a legitimate aim under Article 11.2 of the Convention, that is to say, the protection of the economic and social order by maintaining the legal difference between trade unions and other types of association. And we say that's very close to the aim which is relied on here, because we have a domestic scheme, as from Mr. Cooper identified yesterday, which defines a trade union as one which consists wholly or mainly of workers. If I can ask the court just to turn back a page, look at paragraph 60, where the court said this: in view of the sensitive character of the social and political issues involved in achieving a proper balance between the respective interests of labour and management, and given the wide degree of divergence between the domestic systems in this field, the contracting states enjoy a wide margin of appreciation as to how the freedom of trade unions to protect the occupational interests of their members may be secured. My Lord Justice Green asked a question yesterday about the use of the words labour and management in the EAT's judgment, and I'll make a mental note to talk about that in just a moment. But can I just begin by saying this? The allocation of rights between employees and workers and non-workers, we touched on this morning, in fact. It's a high-level policy decision which attracts precisely the sort of margin identified by the Strasbourg court here, where it talks about the sensitive character of the social and political issues involved in achieving a proper balance between the respective interests of labour and management. It's an echo of Boddington and Lawton, in effect.
It's a slightly tendentious way of putting it, because from a Strasbourg point of view, these are all different kinds of worker. Well, I suppose not. possibly not agricultural labour. Were these self-employed farmers or?
Yes.
Yes, I see.
Had they been employees, they would have been entitled to form the union. It was the fact they weren't employees, as described there. They were self-employed farmers.
Yes, employees, but that I think must mean workers.
They were in an employment relationship for the purposes of Article 11, which perhaps avoids problems.
I'm just using the phrase Article 11 workers. These were not Article 11 workers either, were they?
No. So sorry, I put it the wrong way round.
Yes.
The Romanian law provided for unions to be formed by employees and civil servants. Civil servants, obviously, in Romania don't fall within the category of employees. The farmers, for these purposes, fell outside that rubric.
Yes, although Romanian law used the terminology, or at least as translated, of employees, I think we can read this on the basis that means Article 11 workers, doesn't it?
That may well be right, my lord.
So easy in these cases to slip into our distinction between workers and employees, which is not one recognised in...
Don't suggest that the same terminology is used as in domestic law.
So you're really saying the allocation of rights between workers, between Article 11 workers and non-workers is a sensitive matter. Is that what you're saying?
Well, it perhaps an even higher level point than that, and it's noting that there are political decisions for states to take in terms of how they designate different individuals and how they, for these purposes, balance the respective interests of labour and management. It's legitimate to maintain legal differences within a member state between a trade union and another type of association. That's paragraph 65. And we say that plays itself out in the domestic system, in the well understood system which is used across the spectrum of employment law, as this court noted in Gillam. Of course, the Supreme Court overturned this court's decision in Gillam, but that doesn't render the reasoning of this court in relation to recognising the approach that Parliament has taken to the allocation of some rights to workers and some to employees. To put this case in similar language to Manole, if I may, the state is entitled to protect the economic and social order by maintaining the legal difference between associations of workers and other types of association. And we say that when you look at the present case, it's a good illustration of that principle, because W and Essex tells us that the relationship between foster carers and the local authority is governed by a set of relationships which are not determined by contract, however it is that they arise. Not a contract negotiated between the parties. It's not a contract which can sensibly be the subject of collective bargaining. And of course, you were shown yesterday paragraph 1 of Schedule A1 of the 1992 Act, which talks about rights of collective bargaining on behalf of a group of workers. So one has the features of the 1992 Act and the broader scope of employment law, which use the contract as the touchstone. And then when we look at the particular circumstances of foster carers beyond that, we say, of course, that they're hugely different from those working pursuant to contracts in ordinary workplaces. And the Strasbourg Court recognises that a line may have to be drawn between associations which are trade unions and other types of associations, and the drawing of that line is a matter of policy for the legislature. And we say it is not manifestly without reasonable foundation to seek to have a coherent and workable and legally certain scheme. We also say that there is plainly a rational connection between that aim and the measure in question, which limits trade unions to organisations of workers who work pursuant to a contract which is apt for collective bargaining over its terms, and in particular, as far as we're looking at compulsory collective bargaining, pay and hours and holidays. This argument, if I can just do a brief detour into, and I won't do a detour, I'll stay with it. Disputes about monies paid to foster carers are not claims for breach of contract, of course. It couldn't be because of W&S6. They are claims for judicial review in the administrative court. And we cited in our skeleton argument a couple of cases which are simply examples about disputes about whether foster carers were properly paid, which were dealt with in the administrative court. I don't ask the court to turn them up, but I'll give you the references. It's Redcar and Cleveland Borough Council, Bundle 2, tab 43. And a Crown SA and a local authority, Bundle 2, tab 38. What would the status of a, in inverted commas, collective bargain be in this context? Well, it's not a bargain about a contract. At most, it's perhaps a measure of agreement which might give rise to a legitimate expectation, perhaps, in public law. But it's not the sort of collective bargain which is envisaged by the 1992 Act. If it's a legitimate expectation sort of right, that comes with various public law caveats, which we don't need to go into.
Mr. Collins, if a foster carer working with a direct relationship with the local authority is not paid for what the local authority is supposed to pay him. What remedy is
it's a claim in judicial review.
You say that this person has to go to the High Court to seek judicial review of the failure of the local authority to pay whatever it is.
My lord, yes. Because it's not the same as a local authority who employs a cleaner, for example, and enters into a contract of employment with them. It's a local authority who is making payments pursuant to a statutory scheme.
What about a quantum merit?
Think about that. Well,
quantum merit.
Yes. Well, that would assume a service was being provided to the council on a private law basis, and the authorities tell us that we are dealing with public law relationships.
You also told that labels don't matter.
Yes, maybe they're right.
I think it would be quite difficult, though, wouldn't it, to frame it in terms of a quantum below that? Because you would have to identify specific services which the court would have to value, and the nature of the relationship is such that would be very difficult to do. That's really what your point
yes,
about services.
I think so. I'm far from being an expert in the law of restitution, which is why I'm hesitant in dealing with it. Can I show the court an example which is Redcar and Cleveland, which is in Bundle 2, tab 43. Tab 43, the substantive judgment starts on page 1277. And it's Lady Justice Black as she then was. One can see from paragraph 1 it's an appeal concerning local authority funding in relation to a child who lived with her paternal grandparents pursuant to an interim residence order with an intention that that should be made final. And what was available to the grandparents by funding depended on whether or not she was a looked after child. And so paragraph 3 we see the grandparents argued that Kay was a looked after child and they were entitled to a fostering allowance. And appears to have been heard initially by a district judge, I presume, in the family court. And then we see at paragraph 5 that it became clear during the course of argument that neither the district judge nor the circuit judge, in fact, had jurisdiction to determine the issue. Those were care and residence proceedings. And at paragraph 6, what should have happened is that the grandparents should have challenged the local authority's refusal to pay them a fostering allowance in the administrative court by way of judicial review proceeding. There's an alternative possibility of an application of the High Court under its inherent jurisdiction for a declaration that Kay was a looked after child. And if that declaration had been granted and payment hadn't been forthcoming, then the remedy is in the administrative court. One other case, while we're looking at this, if I may, which is the previous one, tab 42, Exon Tower Hamlets. I'll just take the court to the head note. The head note is a lengthy one, starts at 1261. Can I just ask the court to look at the holding by way of an abbreviated way of dealing with this? The case about a local authority paying kinship carers, family foster carers, lower allowances than other foster carers. And that was a failure to comply with statutory guidance, the court held. The holding is at the bottom of 1261. The local authority had not complied with the statutory guidance which sought to ensure that allowances and fees paid to family foster carers should not be less than those paid to unrelated foster carers. An explanation of the guidance, a policy that absent cogent reasons there should be no differentials between family foster carers and unrelated foster carers. That was a reflection of the statutory requirement in section 22C.
Sorry, well, I'm looking at the holding.
I'm so sorry, my lord.
On page 1227.
1261, my lord.
Oh, I'm so sorry.
Oh, I'm so...
No, it's right. No, I think you were right. I was wrong. I just forgotten that it went... We've got both judgments in the same
That's
tab.
what's happened. I've gone straight to the Court of Appeal judgment.
Yes. No, that's fine. You did say 1261. I just didn't believe you. Okay. Thank you.
It's wise, not the Trust Council.
On the contrary.
Yeah. So there's a failure, you can see from the holding, on the part of the local authority to comply with statutory guidance to ensure that family foster carers were paid as much as non-family foster carers. And then we see at the top of 1262 the failure of the authority to consider and seek alternative fee structures meant a policy of differentials based only on the lack of a pre-existing relationship.
I'm so sorry. Where are you now I found it. Yep. Sorry.
Problem 126.
Yeah, keep going.
Failure of the authority to consider and seek alternative fee structures meant that a policy of differentials based only on the lack of a pre-existing relationship could not be said to carry with it cogent reasons for departure from the statutory guidance. But this is all being analysed in terms of public law concepts. The payments made are not a contractual entitlement. They represent a failure to follow a policy without good reason.
So in the hypothetical JR we posited, which is simple, Mrs. A said, "You have not paid me the last month." Her remedy is to apply to the administrative court, obtain permission, and seek judicial review of the failure to comply with the statutory guidance and pay her
My Lord,
X
yes.
pounds a week.
My Lord, yes. These
That is so, just teasing out, I think, as I say, even if there's no underlying question of principle about what the policy ought to be, which there was in the two cases you referred us to, if there's just a disagreement about a point of fact as to whether they paid her or not.
Inevitably, the reported cases are ones which have issues of principle in them.
Yeah.
But the way in which they're dealt with shows us that the basis for payment is one which is not amenable to private law actions. It's amenable to judicial review.
What's the obligation on the local authority to pay if it's not? What would you, if you go to the admin court and say there's no breach of statutory duty here, there's no breach of contract.
Yes.
I've done something which ain't work. Can you please pay me? What's the basis?
It's that the local authority has failed to abide by either the secondary legislation or its own policies or guidance which it can be expected to follow from government unless there is a good reason not to follow it. These are all public law grounds. One doesn't need to found an action in breach of statutory duty or something along those lines. It's an unlawful decision. It could simply be an irrational decision because the local authority has taken into account an irrelevant factor.
As you say, it may or may not. I know this is a slightly sort of tricky area still, but it may or may not have a basis in legitimate expectation. There's a legitimate expectation that you will follow your policy.
Yes.
But I think it's also now established, isn't it, that failure to follow a policy isn't necessarily rooted in legitimate expectation.
Yes. So there may be some cases which arise from legitimate expectation and others which are slightly different issue, as my Lord identifies, which are more grounded in the policy itself. But whatever the route is, the reason for it being important for our purposes is that we're looking at the structure of an act which makes provision for compulsory collective bargaining in relation to hours and pay and holidays. But collective bargaining doesn't really take us anywhere in the context of foster carers whose rights and obligations do not derive from contract unless the Supreme Court tells us otherwise.
Well, I take your point at one level, but even if W is good law, nobody would jib at the idea that it was an appropriate thing for a trade union to do, to negotiate on behalf of its members, to pay, for example, more than the minimum allowance provided for in the guidance.
I don't dissent with that for a moment. Of course, you don't need to be a trade union to do that, and there are all sorts of organisations like Fostering Network doing excellent work on behalf of foster carers and foster children, negotiating with local authorities over precisely this sort of issue.
Is collective bargaining limited to contractual terms? So
I can't go as far as that, my Lord.
So they could negotiate collectively, compulsorily, public law terms?
Well, compulsory collective bargaining is about pay and hours and holidays.
But that's what we're talking about, clothed in public law garb here. So you'd be doing exactly the same, but you'd be saying for some public law reason, we want better terms.
Well, the starting point for all of my submissions, of course, is that a system has been set up by Parliament.
Absolutely, we understand that.
With a focus on contract.
Yeah, yeah.
And if one wants to use the words collective bargaining with a small c and a small b, if I can put it that way, a group of people can, of course, enter into negotiations with a local authority about all sorts of matters. But it's not what's envisaged by the 1992 Act, is the way that we would put it. And it's just an illustration, really, of the fact that the distinctions have been set up either by Parliament, a worker and employee and so on, for a number of rights. They are particularly relevant in the 1992 Act to issues about contracts, because collective bargaining at its heart is about contractual negotiations. Now, while I accept that one can, in the broadest sense of the word, of course, bargain about ex-local authorities' activities with its local foster carers, NUPFC can do that anyway.
I don't know if it's a useful analogy. If not, we'll move on. But when the Bar Council negotiates with the Ministry of Justice about certain levels of fees for publicly funded work, that's about effectively a public law obligation. Well, I'm not, possibly not actually. There is actually a statutory and/or contractual obligation. I honestly don't know nowadays about what the CPS has to pay, say, or
what might work as an analogy, perhaps slightly more effectively, is in terms of negotiations on behalf of office holders. But if there is an organisation of rent officers, for example, which has meetings with whoever it is.
Rent officers are also employees, though, aren't they? So
yes, that's true. That doesn't necessarily help.
Council and circuit judges might be a better example. I don't know whether they... Anyway, I think probably these analogies are not terribly helpful.
Well,
does your case ultimately boil down to this? I mean, because the way which you have to get over, if you like, my emotional point, that the more one thinks about it, what you're doing is you're saying, we love you, we cherish you, we respect you, we regard you, but we're going to deny you status, we're going to deny you ordinary remedies, and we're going to deny you the right to improve your lot, to which you say, the policy here is to create a black, dark, firm, irreducibly minimum line between workers and non-workers. And there are just tough decisions, and you're one of them.
It's not just tough decisions, though, because on either side of the line are different ways of going about things. So, yes, while it may be so that Bright Line may exclude certain organisations from being listed as trade unions, but not others, that doesn't mean to say that they will be treated less well.
But you just explained how they've got to get... They can't even bring a claim in court without going to get permission.
Well, that's nothing to do with listing, my lord.
No, but it's a consequence of the harsh black line, dark line between in and out.
It's not a consequence of anything to do with trade union membership or listing. It's a consequence of the way in which
Maybe it's a
the relationship is structured. Yes, I mean it is a consequence of that. So it's not. It's a consequence of the fact that there's no contract. There is no doubt that it's easy to enforce a contract by way of a private law claim, and if you don't have a contract, you've got to look to some alternative route. That's a fact of life. I've taken you to those cases and to explain those differences, not because this is the decision which is in issue at this case is what results in the foster carers needing to bring their claims in the administrative court, but just that that's another illustration of the fact that the sorts of relationships that we are dealing with in this context are very different from the relationships which are between workers and their employers. the bit of the argument that we're in at the moment is legitimate aim, and looking at a legitimate aim of maintaining distinctions between different kinds of relationships and different kinds of organisations. And that's a we would say a very high level policy aim, and that's why we're in manifesto without reasonable foundations here.
Another possible area of analogy is probably not going to be helpful, but I throw it out there in case it is. The clergy cases go in different ways, and Church of England is a clergy, incumbent of the parish as an office holder. Methodists, we now discover, are not employees, I don't get that the right way around, not even workers. In the Church of Scotland, they are workers, if not actually employees. But just take those ones which are, in fact, take a Methodist minister. They got a stipend, if I remember the facts of Preston correctly.
Yeah.
But it was not regarded as a wage-work bargain.
Yes.
Perhaps more relevant to an earlier part of your submission.
Yes, but that's what. Yes, it's relevant to the submission that I made, is that it isn't enough to look at the fee. One has to look at the legal rights and obligations which give rise to it.
It was provoked by your general point. This is just a different kind of relationship which attracts different kinds of legal remedies, and in certain circumstances you might still be able to claim for your stipend. But the whole analysis is different, and the legal legal consequences play out differently.
My lord, yes. And Strasbourg tells us that that's a political balancing. Just to bring that back to trade unions, because I've drifted away a little from trade unions. Which kinds of relationships go into trade unions and which don't, and how one defines those relationships is a political question. Legislatures decide by reference to balancing the respective rights of labour and management. My Lord, Lord Justice Green asked yesterday what the EAT meant by that, and I think my suggestion is that they're simply reading across from those cases, because that expression makes its way from Strasbourg into, I suspect it's in both Boots and Vining, I'm not entirely sure, but I suspect it's there. And that's the policy decision which is taken by government as to which organisations are unions and which aren't. But it's not really applicable to foster carers at all. We don't have labour and management in the context of foster carers. That's not the way the system is structured.
I suppose that relationship is very closely governed as between the local authority and the foster carer. As far as there's management, it's a fairly rigidly and exhaustively governed set of rights and obligations.
Well, yes and no. In terms of rigidity, one can see from many of the reports, which I'm going to come to shortly, that sort of rigidity of supervision certainly shouldn't be there, so far as the local authority and the individual foster carer is concerned. That the idea of independence and foster carers treating foster children as they would their own children, rather than having to pick up the phone to a manager and say, can I do X or Y? As Krasner, I recall, on the first morning talked about sleepovers, and I can show the court the guidance in relation to that.
I think you're accepting that the Act itself doesn't rely on that. The Act is really a relationship, is governing the divide between different types of association or workers' groups, not between management and the employees. It's a horizontal delineation. The management issue comes into relationship, which is, you say, offside, namely foster care and employer.
Yes, the package of rights and obligations which a legislature gives to or imposes upon trade unions is the balancing act between the rights of labour and management. As to who falls into which category, then my Lord's right. That's a different issue. Can I then turn to the other legitimate aim, which relates to the children, and that perhaps is perhaps unfortunate that 2:30 on day 3 before I've been able to talk about this, because this really is at the heart of it, because the Secretary of State's concerns have always been that to include foster carers alongside workers as those individuals with trade union rights of the sort described by Lord Henty yesterday, the day before, gives rise to a risk of adverse consequences for children, but a group of particularly vulnerable children. And to address you on this, I need to come back to those reports which I highlighted at the outset of my submissions. So can I ask you to turn, please, to the supplemental bundle? Can we start, please, on page 492, which is within fostering better outcomes, that is within the government response for the work that was done. And the starting point is the Secretary of State, what's described as our vision for foster care. Our vision is for all children in foster care to have stable lives, establish trusted relationships, to feel cared for and to benefit from high quality foster care as long as they need it. We want a care system in which children and young people can experience a, quote, normal life, and to have the opportunities that other children have access to. Children's needs and views should be the driving force for all decisions made about their care. But that's the starting point of the perspective that the Secretary of State brings to this analysis. Can I give you some facts about foster care to begin with, please? Page 15 in the same bundle, from the witness statement of Katie Willison.
Yes.
Page 15, paragraph 3 and 4. As at March 2018, there were just over 75,000 children looked after in England. 63% are in care as a result of abuse or neglect. 29% removed from their birth family as a result of family dysfunction, family in acute stress, or absent parenting. 62% of them are over 10 years old. 73% are in foster care, so that's just over 55,000 as at March 2018. That's a significantly higher proportion of family care than many other countries. That has been a conscious decision over time to offer vulnerable children and young people the chance to experience a stable, warm and loving family home. So only 11% of looked after children are in residential care, residential or secure care homes, as an example of one other country where the proportion's the other way around. The Secretary of State has been, where possible, to offer these children family life, a chance to grow up in a family. And that decision is both based on and supported by what the children have to say about it. Can I take the court to what the Children's Commissioner says at page 550? This is in her foreword to the NARI report, 550. Second paragraph, our ambitions for foster children should be high. Children in foster care tell me they want to live in a family that has the same expectations for them as they would have for their own children. With foster carers who do all they can to help their foster children succeed and thrive as they grow up. by the lower hole punch. Children in care often tell me they wish they could be treated like all the other kids. And then over the page at 551, the last paragraph. In the end, more than anything, foster children want to feel they're part of a family. A family life built on strong, valued relationships provides them with a sense of belonging and stability, and most say it is by far the best thing about being in care.
Can I just mention one thing? There are figures somewhere out there about the proportion of foster care placements which are long-term or short-term or medium-term, about duration anyway.
Yes, there will
Because
be, I'm
there
sure.
I wouldn't mind being referred to those when you or someone behind you can find.
I'll ask Mr. Moretto to start work on that. But yes, I'm sure we can find those
It
figures.
is simply to make the point. I'm not quite sure where it goes, but it possibly goes against you that a lot of, anecdotally I'm aware, that a lot of placements are quite short-term, weeks or a few months. And although there too, I absolutely understand the importance of it being in a home and with a family, if it is short-term foster care, it's never going to be with a family in the same sense. You're not going to call the foster parents mum and dad. You're not going to see them as substitute parents.
Well, one may not know that on the day when the child arrives.
Well, you may
With
not,
the
but
family.
quite often you do.
But the figures won't necessarily
No.
tell us that.
Well, the whole case isn't going to turn on this, but it's simply a nuance to the point that you were making.
My lord, yes. Not a note. Let me just see if that's going to answer my lord's question. My lord, page 565. Great for Mr. Moretto.
I ought to know this, but I don't. I'm sure a family lawyer would. Is long-term fostering a defined concept that more than 1 year or more than something?
My lord, I don't profess to be a family lawyer either. I'll try and find out the answer to that question. I'm sorry I keep having to say I'll find out the answer, but I don't have all of the information, I'm afraid, at my fingertips.
Unless I'm missing it, there's lots of figures here, and I'm sure this will be helpful, but does any of them actually answer my question?
I haven't found it yet, my lord.
Well, Mr. Moretto presumably had a particular bullet in mind. Okay, well, let's
My lord,
not spend time on it now. Let's come back to it later. Yep.
I'm grateful. I was going to take you to...
Sorry, just before we move on, there's some interesting financial figures again. I'm not quite certain where they take on. Bottom of 566, 567, about the rates, the range of the rates of pay.
Yes.
And that most carers get a fee in addition to the weekly allowance.
Yes.
Which are
Yes,
described as remuneration of foster carers. Yep.
My lord, yes. So the recommended national minimum allowance is intended to deal with the costs associated with foster care, and then one has the figures, or rather one doesn't have the figures, but one has the statement that most receive a fee in addition, but we don't have figures about that.
If the minimum, the ceiling for the minimum is 219, the average is 634, and the spend is from 350 to around 900.
My lord, yes, and there's some...
What we can't work out from that, though, is where there are fees paid, what the range is, and what the proportion of fee bears to the allowance.
My lord, at 562, very grateful to have been passed a note. The third bullet point provides some information about the duration of foster care placements.
Third bullet point on 565?
562.
562. Well, that's pretty good, yes, thank you.
So insofar as my lord said that the points in relation to short-term placements might be against me, respectfully suggest not. This is all about the experience of the child, and the experience of a child arriving in a family home, even for a short period of time, is incalculably different, we would respectfully suggest, than arriving in a children's home.
Yes, well, I see that.
My lord, I was about to take you to the Children's Commissioner's survey, which starts at 649.
Sorry, did you say 569?
649.
Oh, 649, I'm so sorry.
I identified the document as a whole for the court this morning. One can see at 650, the Commissioner having gathered the views and experience of children in foster care. And we look at 651, please. What's the best thing about being in care? Feeling like part of the family is the first thing we see there. The majority stated that the best thing about care was their foster family and feeling like part of the family. Some young people indicated they viewed their foster carers as their mum and dad, and the foster carers' children as their brothers and sisters. Many enjoyed doing activities with their foster family, such as going on holiday and family days out. There's a further quote there. The best thing about being in care is the family I am now placed with. I see my foster carers as mum and dad. And the court can see for yourselves the various quotes. We take issue with a submission made at one point. I think it suggests there was only one positive quote. 658. What do young people want from their foster carers? And we have again, what's the first thing? To feel part of the family. An overwhelming majority of young people stated they wanted to feel safe, loved and part of the family. Many recognised the importance of identity and belonging in shaping their own happiness and well-being. Another quote there, to feel part of a family. Oh, my lord, that family experience is something which the Secretary of State sets enormous store by. Can I ask the court next to turn to another survey?
Can we look at 660 just before?
So sorry.
On, which is also under the heading "What the Young People Want," which the answer is more money for the foster carers.
Am I not say 668?
660. Sorry.
It's zero.
Zero. I'm so sorry.
No,
It means under the general heading, what the young people want.
Yeah.
Yes. On 658.
Increased finance. Yes, absolutely. Of course, I'm not suggesting that all these reports say there's only one thing which is needed, which is a family. It's a family which is not only loving but also adequately resourced to provide the care that is needed.
Yes, and actually this is rather a particular point. If you look at it, it's a point about the foster parent having more money to give to the child.
Yep.
For older teenagers, I assume, and they, and particularly those who are leaving, your real parents might give you money when you left home or support you when you left home. That seems to be the sort of point that's being made,
Yes, and not
rather than that they want better remuneration for their parents.
Yes, and one can see that the child's focus is, they're asked what would be important for them. So they see that quote, foster carers need more money so they can help us. I'd like pocket money and more school funding and so on. Of course that's right.
There was some suggestion yesterday, I can't remember where the quote comes from, that the children don't want their parents to have more money because it might undermine their relationship with the parent, which I found slightly counterintuitive.
That certainly wouldn't be my submission. No, the idea that the children don't want their parents, the foster parents, to have more money is not something that I would suggest at all. There's a difference, however, between the proposition that children may want their foster carers to have more money to be able to help them, and saying that the consequence of that is that those foster carers should be entitled to trade union rights and be picketing a local authority to say, I need more money to be looking after my foster child.
There's no suggestion by the Secretary of State that if they were workers, this would undermine the familial relationship between the parent and the child.
There is a suggestion of that, my lord, yes, and I'm going to develop it.
Right.
But certainly from the perspective of the children, there is a real risk that if they see their foster carers as doing a job looking after them, rather than looking after them because they love them and want to do so.
Even if doing a job enables them to have that surplus amount of money to give them pocket money.
Well, that's why I've taken you to the comments about the children. What is the most important thing? Is it how much pocket money they get? No, it's feeling part of the family. Of course they want the family to have enough money to take them for days out, and as any child would. But feeling part of the family is important for some of the reasons that I've taken you to already. Can I take you to some of the other quotes to explain why it is that we say that? Starting with the Ofsted survey at page 193.
But you were mentioning various bits of evidence about what children think. And there's one young man whose what he wrote to the reviewers is quoted in the review and quoted in Ms. Willison's witness statement as apparently being of enormous importance at the bottom of page 24 of this one. And this is one man who was told by his long-term foster carers that he and his brother were just a job to them. This made us feel worthless. And it's no better than being with our family, which foster care should never be like. Vulnerable children being promoted as a means to make money is wrong. Why is that response evidence of anything that's relevant for us to decide?
It is evidence of perhaps nothing more than the importance to children in foster care of feeling that they are part of a family. Now, of course, I don't suggest that that quote means that if foster carers become workers, they'll start to talk to their foster children like that. Of course, that's no part of my case. It's an illustration that one of the concerns that children in foster care have is that they are being looked after because they are part of the family and not simply because it's somebody's job from which they make money.
The point is this, that it could well, it's one anecdote which could well be an outlier, which is presented because it's simply in isolation, almost as reflective of the norm. I think that's the point. It's not necessarily a fair piece of evidence to present as reflective.
Well,
I understand we've seen a lot of evidence, and it goes both ways. But part of the problem here is the EAT didn't really address much of this.
Well, the EAT certainly relies on having taken into account these reports. They're referred to, although individual passages within them are not cited in the EAT judgment. Don't accept that it's right to say that this is a quote which is taken as the sole piece of evidence, because it's there within a witness statement which appends all of the reports, which I'm taking the court through now. It's an illustration of a stark scenario, an unsatisfactory scenario. But the Secretary of State's submission...
Paragraph 49 puts it out as effectively a reflective incident. It's describing what would constitute employment status for foster parents to young people and their carers is met with confusion and in many cases dismay. This is the evidence for it. Anyway, I mean, I understand the point. I mean, you know, there's not great deal to be gained from just picking over individual incidents.
No. One of the reasons that it's been important for me to take the court through a number of passages is that plainly it would be wrong for me to say there is one quote which shows a foster child who felt it unsatisfactory that their foster parent had said that they were treating them as a job. Now, that's not representative of foster carers, worker status or no worker status. And I'm sure that's clear from the way in which I opened my submissions and the way we've dealt with
ultimately, all these individual quotes are just illustrative. They're of no value because they have no statistical value. What is of value is the opinions of the people with experience in this field who refer to them. And those obviously include the authors of each of these reports.
Yes.
Particularly perhaps Nary and
Owens.
Nary, Sir Martin Nary,
Mark Owens.
is Chief Executive of Barnardo's, is that, or certainly has been?
Yes.
What's Mark Owens' qualification?
My lord, he's described...
He's described by Sir Martin Nary as a curious hybrid. Part children's social worker, part civil servant, and a personal contributor to the care system, having adopted 2 of his 5 children.
That's the biography I was going to draw your lordship's attention to.
Yes.
That's perhaps the best summary that I can offer.
Yes. But it's always going to be, to some extent, a matter of judgment and impression. But it's judgment and impression by experienced professionals, looking at the kinds of individual examples merely illustratively.
My lord, yes. And the Secretary of State has commissioned an enormous amount of information here. So we have the Baginski report, which is a collation of evidence itself. So one sees how many different sources of information feed into that. In response to a question that was asked this morning, Baginski was commissioned specifically with the aim of informing Nary, if I can put it that way, to provide raw materials for Nary to look at. And then what Nary says is, I took you to this morning at 548, we haven't investigated every fostering related issue, but we have probed every issue which we were urged to review by carers, professionals or children and young people. So this is an enormous goldmine of information. I'm going to have to respond to the submissions from ECRU in a moment, and we say that the representation of the work that's been done is really rather unfair.
Yes. Now, we've taken you off your course. You were about to take us to S193. Perhaps you had.
Perhaps I'll just ask the court to note it. It's another example rather than a point of principle, if I can put it that way. But it's from another survey, from Ofsted. With one eye on the clock, can I instead ask you to look at Sir Martin Nary's conclusions on employment status at page 589? In fact, on that page, just before the heading of employment, there was discussion about whether foster carers are paid enough. Nary and Ower's conclusion, the paragraph above employment, 4 lines down, we do not believe current payments, when considered in the context of tax and benefit arrangements, are inadequate nor to be an obstacle to recruiting high quality carers. And they say they do not agree with Sarah Anderson from the Foster Care Workers Union, whose witness statement is in the bundle, that most foster care workers are underpaid. I draw your attention to that only because there was a query, I think, from my Lord Justice Green about extent of payments, but it doesn't seem to me, in fact, to take us any further. But what Sir Martin does do is to deal with the calls for foster carers to be regarded as workers or employees, reference to the Foster Care Workers Union and indeed the IWGB, as well over the page as the GMB. I suspect the court may have already read this passage, but if you haven't, can I invite you to read it for yourself?
On 590.
Yes. My Lord's right to say this is ultimately a question of judgment. One can't make use of statistics to identify consequences of something which hasn't been tried and something which depends to such extent on perspective apart from anything else.
Is this the time? Obviously I take that point. To some extent, I made it to you, but can I change the subject slightly? But it rises directly out of this passage. It looks to me as though what Nari and Owers are very much against is employment status for carers. They aren't really distinguishing between employment status in the terms of having individual employment rights and employment status in the sense of being entitled to join trade unions. They refer to the fact that some foster carers have already joined trade unions as a sort of intro to the more general point they're making. But how do you meet the point that, Lord Hendy's point, that to have the right to be a member of a trade union in which you are yourselves the majority isn't at all the same as being an employee or worker in substance? It is true, of course, that the same test applies to both under our domestic legislation, but that is the cause of the problem rather than the answer to it, unless you're right in your Manoli point.
Well, what the appellant's case seeks to do, I suppose, is to have foster carers treated in the same way as workers for these purposes. And then we get into a very difficult balancing act whereby either doesn't really have any consequences, the listing, as what one argument puts it in this case, very limited consequence, in which case I then accept that the argument is put back to me, well, one can't really justify interfering with it then if it doesn't really have any consequences. Whereas we would say, well, it's a very limited interference in that case, whereas therefore it's easy to justify. When one looks at it the other way, and Lord Hendy gives you the long list of consequences which ultimately flow from providing trade union rights, having passed through the gateway of listing, as it's been described, then that is much more significant. And in those circumstances, although it might be said, well, if there are a greater number of rights which are being withheld, a correspondingly more powerful justification is called for from the respondent or the Secretary of State, or both. Equally, one can say the more those rights are made available, the more significant the change in the perception of the environment in which these children are being brought up. And I understand Lord Hendy's submission saying that nobody's realistically suggesting that anybody's going to go on strike. But even if we don't go that far, well, of course, all rights are theoretical to begin with. The idea of picketing to secure greater holidays? Is there really no risk that a child in foster care is concerned at the possibility that their foster parent can be picketing a local authority to say, I need to spend more time away from my foster child? And that wouldn't be a fair way to look at it. And respite care is important and absolutely necessary part of the foster care package. But when one sees it through the prism of picketing or rights which start to look much more like workers' rights, then the Secretary of State identifies a risk. And nobody can put it higher than this, that there are potential benefits and there are risks with taking this step. And the Secretary of State takes the view that it's a risk which is not fair to the children to take.
Is it? I don't say this in order to denigrate it, but to take the easy cliche, is there an element of a slippery slope argument here?
On the one hand, it wouldn't be fair of me to talk about an increase in trade union rights as a downhill slope in one sense. So the metaphor isn't one that I would choose, but if I understand what my Lord means by it, then yes, if I can borrow yesterday's metaphor of gaining entry to the fairground, then there is a range of possibilities there, all of which tend to, maybe individually, each of them might not seem dramatic, but the package tends to transform the way that one sees the concept of family care and foster care.
Is it the Secretary of State's position, that although the law allows it at the moment, is in principle undesirable, that foster carers should be entitled to join a trade union of which they are minority members?
No, that's not the Secretary of State's position. Because they can do that. It's perfectly possible for anybody to be a member of a trade union without being a worker. So the membership of the trade union doesn't transform the nature of the home, if I can put it that way, in the way that creating a worker relationship may do.
You use the example of picketing. Perhaps it'd be more realistic for the compulsory bargaining to have as its subject how one reconciled the needs of the foster carer perpetually continuing to look after the child with the need for respite. One imagines those would be on the agenda. How do you get a better balance? How do you afford it?
Yes.
Why is it? There's an element of exaggeration to say this boils down to picketing and we're going to go on strike and leave the child at home without care. It's going to be more nuanced and sophisticated than that, isn't it?
Well, first thing to say is that there's nothing to stop collective discussions of the sort that my Lord describes at the moment. You don't need to be a trade. You don't need to be a trade union to do that. And of course, the reality is we are not suggesting that worker status is going to transform the foster carers themselves, if I can put it that way. It doesn't make them less caring people. I wouldn't make that submission for a moment. We know that the majority of foster carers become foster carers for altruistic reasons, either in relation to members of their own family or otherwise. But there is something significant about transforming a family home into a workplace. And if that significance is no higher than a perception on the part of some children, then that is enough in our respectful submission. Because the needs of... I'm so sorry.
Mr. John.
The needs of the children outweigh everything else in this analysis.
But is it the needs of the children or the perception of the children? Well, the young man in the example at S24, which I didn't much like, was told by his foster parents, "This is just a job to us." Well, of course, that's outrageous. Yeah. But why? Your position almost seems to me to lead to the view that if children are aware that their foster parents are being paid, that they might perceive this as being just a job rather than a family, because after all, birth parents aren't paid.
That's not my submission, my lord, and plainly that wouldn't be right.
But why should it make any difference to the perception of the child whether foster carers are paid or as they are now, or whether in addition they are allowed to form a trade union which seeks to persuade those in authority that the rates of pay are not sufficient? Why does that matter?
My lord, the difference is that once one has the NUP listed as a trade union, one identifies that the majority of its members who are foster carers are treated in the same way as workers. The assessment of, or the judgment of, some of those who have advised the Secretary of State is that that is liable to have a harmful effect on the family-centred nature of the relationships for the children to understand that they are in a workplace rather than a home. Now, I absolutely accept that there is more than one possible view on this. My lord may take the view that, may take a different view. But it's a question of judgment. It's the judgment of Sir Martin in this report, which is supported by the Children's Commissioner. And it's a judgment reached on the basis of the vast amount of material that we've drawn your attention to. It's supported by the Select Committee of the House of Commons. And the question for... I'm sorry.
I just want to be clear about what Mary says. I'm not certain he deals with the question of perception of children. He's certainly quite strong, absolutely right, on page 590.
Yes.
But I don't read... I mean, his concern is about the introduction of more obligations, more insight, and impact on the independence of carers, and that turns it into a place of work. Unless I've picked up correctly, he hasn't dealt with the perception of children. And in the forward by the Children's Commissioners, I'm not certain she draws the connection between pay and perception.
No, and of course that's right, and it's also fair to say that this is a long report, which employment status has 2 pages in it. And it's also right to say, the point has been made, of course it doesn't directly address the question of listing trade unions. And nobody, it's fair to say, seems to have raised that. We'd also suggest we note that nobody on behalf of the carers raised that with any of those asking about it. Sir Martin.
Your point, which I understand the relevance of, which is that there's a sui generis nature to this relationship.
Yeah.
And all of this demonstrates that. The question is, what inferences do we draw from that? If one says that it actually is harmful to treat them as workers because of children's perception, that's a related but different point.
I think it's probably right to say that the concerns which are raised in the reports are not confined to one particular issue. It's not simply independence, not simply perception. It's not simply the way in which local authorities and carers' relationships are organised. There is a broad concern raised by Sir Martin Neri that employment status would not be helpful. My Lord asked at the outset of my submissions about recommendations. And having now mentioned it,
So just before we leave 590,
they're set out.
My Lord has pointed to the paragraph about two-thirds of the way down, but the quote from Martin Barrow in The Guardian does seem to be more about it doesn't use the word perception, but it would have a profound impact on the relationship between foster carers and ... most important of all, the children and young people in their care, which I do take to be essentially the perception point.
My Lord, yes. It's fair to say none of the people who have contributed to these reports or expressed conclusions in them have thought about it in the sort of detail which we're analysing it over 3 days in the Court of Appeal.
Mr. Burton pricked up his ears when you said that.
Doesn't help him, my Lord, much as he might think it does. Nobody has picked over line by line what is in these reports. What they have done, if it enables Mr. Burton to sit more comfortably in his chair, is focus all of this on what is in the best interests of the children. And the conclusion reached by the Secretary of State is one which the EAT was entitled to accept if it was not manifestly without reasonable foundation, and which this court can only interfere with if you are satisfied that the EAT failed to do its job properly.
I see the time, and we've spent a lot of time on this aspect quite rightly because it's important for your submissions, it's important for us. You want us to keep quiet and let you develop important points you haven't yet dealt with at all. I suspect you actually have got to the nub of it, but I'm sure there was more you wanted to say.
Dealt with quite a lot of it. I need to deal with Mr. Burton's submissions, which I haven't.
We'll let you do that.
Can I just say what we say the conclusion from the sort of lengthy passage of discussion that we've just had should be, which is this: when you take the context into account, the submission that the policy decision to define trade union status by reference to the membership being workers and not foster carers, the idea that that's not rationally connected to the rights and well-being of children, we say is untenable. And we say, more broadly, the way the decision, the conclusion that is reached is not manifestly without reasonable foundation. And we say, this is to go on to deal with the ECRU case then. Again, the contention there's been no proper assessment of the best interests of the child, respect is plainly wrong. The focus of all the material is how best to reflect the interests of children in the foster care system. That's what all of these reports are about. Of course, they're not aimed at the question whether an association of foster carers should be listed as a trade union, but questions relating to the classification of foster carers as workers plainly are considered. And that's at the heart of what we're talking about. should there have been a separate child rights impact assessment? And drew to your attention that there's a template or a form which exists. It was launched in May 2019, my lords. So it was not launched until after the hearing in the EAT. So that's the explanation why that was not used.
What date?
May 2019, my lord.
Yeah, okay.
It's I take that from a footnote. The footnote, paragraph 25 in Mr. Burton's submissions, has a hyperlink, takes you to the web page. It makes it clear that the document is generated in May 2019. It didn't exist before that.
I can't remember who generated it.
It's generated by government. I'm pretty sure it must be the Department for Education. But risk of stating the obvious, this isn't a case about whether a best interest assessment has been carried out. The question of a best interest assessment arises in the context of your analysis whether any interference with convention rights which you find is justified. And can I address the timing question? Because my lord asked the question at one point, when did this have to be done? Well, we know from the documents that there was a stocktake, a fostering stocktake, which began in 2016. We also know that for the first year or so of this appeal, that is the appeal from the certification officer, Secretary of State wasn't a party, wasn't notified of it until the end of 2018. And there are then, well, in between December writing in to say Secretary of State would like to intervene and the hearings, a period of about 3 months, during which notice of appeal is re-amended. The focus of the case changed. At one point this was a case based on EU law, now it's based on human rights law. We respectfully suggest it's remained unclear, as Mr. Cooper submitted yesterday, exactly what it is we're meant to be justifying. I wonder what ECRU suggests should have been done. Should the Secretary of State have sought an adjournment for, as my Lord Justice Underhill suggested, a major piece of policy work? I ask rhetorically, for how long? A year? The reality is, as I've already submitted, the best interest assessment question just arises in the context of justification of interference. And we'd respectfully suggest that the Convention on the Rights of the Child points, which Mr. Burton raised, actually have a relatively limited role to play in your analysis. The procedural requirement, which features heavily in Mr. Burton's submissions, is dealt with, given the time. I'll just give you the reference if I may. It's C and the Department for Work and Pensions, Bundle 3, tab 64, page 1992, paragraph 116. It may also be helpful to look at paragraph 112 when the time comes. Procedural requirement doesn't really add anything. You will examine the evidence in support of each party's case as to whether interference with Article 11 or 14 is proportionate. To that extent, you'll look at the sufficiency of the Secretary of State's analysis, not for its own sake, but for what the content tells you. Firstly, to see what the evidence shows, and secondly, because the extent of the deference you pay to the policy decision will depend whether the analysis was undertaken at the time or ex post facto, in the misbehaving sense. And this isn't a case, of course, about discrimination against children. What the EAT properly considered, with the benefit of all of the material that we've looked at, was the risk that treating foster carers in the same way as workers might transform the home and family environment into the workplace. What we do note is and I echo Mr. Cooper's submissions on this issue, ECRO doesn't say there's no problem. It says there appear to be risk factors on both sides, and that gives rise to the difficulty which the court has already considered. What's the effect if you agree that the issue hasn't been sufficiently considered? And we say it's a surprising submission from ECRO to say that even though a fuller analysis is needed, you simply reject the defence and fine for the appellant, even though it might turn out on fuller analysis to be harmful for children. To say you should take that risk on behalf of the children, we say can't itself be in their best interests. On the contrary, we say if it appears that there may be both positive and negative consequences, two potential results. Firstly, to err on the side of caution and not to pursue a course which gives rise to a risk of negative outcomes, even if it might also bring positive outcomes. Or alternatively, to recognise this is precisely the sort of matter which the legislature is equipped to deal with and the courts are not. And we say this is precisely why the authorities tell us that the choice of the legislature in these sorts of matters should be respected unless it's manifestly without reasonable foundation. There is a constitutional difficulty, we say, where Parliament has concluded it's not appropriate to give these industrial rights to foster carers with the benefit of the views of the stakeholders that we've identified. And one sets against that, not quite, nothing more than assertion, but not much more than assertion from the appellants. Put it another way, we say that's why you should give a wide margin of discretion to the legislature, to the legislator. We accept that listing isn't wholly valueless. We say it's of modest value, given on the one hand the extent to which it can achieve, NUPFC can achieve its objectives without listing, and on the other hand, the further steps which would need to be taken to obtain the benefits for which Lord Hendy contends, and the fact that the union can achieve its stated aims without listing. Those aims I invite the court to look at. They're set out at page 709 of the supplementary bundle. Short and sweet, they don't require trade union status. My lords, I'm conscious of the time. I think I've said what I can say on the important issue of justification. Can I just ask for a few more minutes, firstly to deal with remedy, or I don't know whether my lord would prefer to hear me at the end of the day on remedy.
I think we prefer to hear you now, but it's got to be a few more minutes.
It will be a few more minutes, my lord. I had been intending to address the court on other status as well. I'm just going to give the court one line, if I may. The second sentence of paragraph 32 of Gillam cannot mean that Lady Hale intended to say that working other than pursuant to contract is an other status, because that would fly in the face of the independent existence criterion, which the appellants accept rightly is a criterion, and it's one which Lady Hale herself in other Supreme Court judgments has upheld. Gillam is authority only for the proposition that being a judge is an other status. That's clear from the first and third sentences paragraph. My lord, on remedy, that I can be very short because my submission is this. The remedy originally sought was reading down of section 296. The court has mused on that and mused on other alternatives in the course of 3 days of submissions. In a case of this significance, it would not be right for us to be rather making submissions on the hoof against a possibility of a range of potential remedies which might have significant consequences for the 1992 Act. And in particular, if the court were minded to be thinking about a declaration of incompatibility, that would require submissions to be made on behalf of the Secretary of State for Business, Energy and Industrial Strategy, the best course in our respectful submission would be not to decide remedy at this stage, for the court to reach its judgment on the substance, and if the appeal succeeds, at that point to hear submissions on the proper remedy in light of the findings that the court has made. It would be very difficult for us to give the court coherent assistance this afternoon.
Yep. Very well.
My Lord, I think I've used all the time I sensibly can.
I think you have, unless my lords want to prolong it. They don't. Thank you very much indeed, Mr. Collins. It's been very helpful. Ms. Krasno, you first, anyway.
We're going to address you in the same order as we did originally. My going first, then Lord Hendy, and lastly Mr. Burton. I have a lectern back. Stop, Collins.
Yes, thank you.
Thank you, my lords. I'd like to make a couple of brief comments in reply to what Mr. Cooper raised with your lordships yesterday afternoon in relation to the sequence that the appellant has sought trade union rights. It was said to the court that what we should have done was to have waited until we had substantive matters to grapple with and then gone, if we needed to the CAC and said, can you deal with A, B and C together? And then it said a proper justification analysis could have been done and we'd have had something to get our teeth into. In our submission, we have gone about this in the right way, and we say it's a logical way to approach the securing of listing. And there are even two very simple reasons for this. Before I even get to the notion of it being into the fairgrounds and then look at the rides. Your lordships will recall that what paragraph 6 of Schedule A1 to the 1992 Act requires is that the request for compulsory recognition is not valid unless the trade union has the certificate of independence. So, if that request is made in due course to the CAC, and the question's asked, well, where's your certificate? And the trade union answers, oh, I thought you could sort that bit out for me because it might have been a bit of a waste of time for me to have bothered with the preliminary stages. Not surprising, we submit, if at that stage the CAC says, get back to the certification officer. She's got jurisdiction to deal with 1 listing and 2 certificate. Why are you wasting my time asking for that here? And that in itself shows this is the right way round. And secondly, since it appears that everybody accepts, we are seeking to have section 296 read down for section 2 purposes, getting into the fairgrounds. That we say is obviously a statutory benefit in itself, because it allows us to get to the stage, one where we can act as the recruiting sergeant, and secondly, where we can consider, are we going to seek that request for compulsory recognition in due course? And if we are, it makes sense to have the certificate in our pockets by the time we do it. Of course, the future hurdles of getting on the rides remain. But in the fairground already, we have unions such as the GMB and the IWGB. They're already there. if we are allowed into the fairground, we're simply in the same position as those listed trade unions. We catch up with them, and now we, like them, have the further hurdles of overcoming any Article 11 justification defences for substantive rights. And it's at that stage, we say, that Mr. Collins can, in a more relevant and rational manner, raise and pray in aid his arguments that he's mentioned this afternoon about potentially adverse consequences to children. So we say something like, the perceptions or concerns that he mentions about a foster carer picketing to get holiday rights are of absolutely no relevance to this entrance to the fairground stage. Might they be relevant down the line? Perhaps. But the very fact that they have no bearing on this matter helps us see that they are distinct and separate rights, albeit different stages along the way. And that we've chosen to go to the first gateway or threshold is something that, in my submission, we should be commended for and not criticised.
You're using substantive rights to mean individual employment rights under the 1996 Act.
I don't get to that, actually, my lord. I mean, under the 1992 Act, collective rights.
So you say this is listing and certificate of independence and no more.
Yeah. And my lord, when your lordship looks back at how the case has been put in terms of at the EAT, in our grounds of appeal and in both our skeleton arguments, I hope it'll be seen that that's been consistent throughout. I'll say a little bit about the evidence before the EAT and children in a moment, but can I first make some very brief submissions in reply on employment relationship? Mr. Cooper raised the Good Shepherd case with you to support his submission that one could look at special features as to why an employment relationship did not exist. Now, in that case, the priests did work under an employment relationship, and the factors there that were found to amount to a justification weren't significant enough to have any issue to prevent them being workers. And there's been no explanation.
Sorry, what's justification got to do with whether there's an employment relationship
Well,
in the first place?
in terms of the special features which are raised, in that case, special features of spirituality were put forward and said
I
that
understand
those...
that. You used the language of justification,
Well,
and they've misunderstood you.
I'm so sorry, my fault. In that case, there was... the state had a two-pronged attack on the attempt to demonstrate Article 11 interference. Firstly, it was said the spiritual nature of the duties meant there was no employment relationship. That failed. Then they went on to provide a justification defence which succeeded on those particular facts.
Right.
But here, it's not been said why the special features exist, which could be more distinct than the spiritual nature of factors which could apply to the clergy. And in particular, my lords, you've had no reply to what we've relied upon as being examined in the Romanian foster carers case, Sindicatul Constanța Familia, where we took you to the consideration by the European Court referring to why it is no less work for being done in the home and akin to parental work. And just for your lordship's reference, the page reference to that is Authorities Bundle, page 3005, paragraphs 46 to 47. And likewise, we rely on the logic, not binding reasoning, but it's very persuasive in our submission, from the domestic Scottish Appeal Court in the Johnston case, at paragraph 25, Authorities Bundle 1834. And the reason why that's particularly persuasive is because of the similarity of the role. Cared for children being looked after in the home. To say that caring is not working, we say is both outdated and misguided, and I need say no more in reply to that submission. Nothing new has been raised further than what we said in our original submissions. In response to my Lord Green's comments that the foster carers are the mechanisms by which the local authority discharges its statutory obligation to look after the child, seems to us there's no answer to that in terms of the economic activity which is carried out. And to say, because it's done in the home, it's not valuable labour of some kind, we say is simply misconceived. But let me come to the remuneration element, which is clearly the point which caused the EAT key concern, although as we've seen today, the EAT focused almost completely on the fact that the evidence relating to a member of that trade union, of the appellant trade union, only seemed to receive an allowance. What we know about reward is that no foster carers do the work for free. They're clearly not volunteers, and they
hang on. What you say that as if that's obvious. If they only get an allowance, they do the work for free, don't they?
We say no, because that work compensates them for what they're doing, even though it's called covering general costs.
Well, that's an assertion on your part, but the way it's explained in the paperwork we have seen, we know reasonably this is a sham, is that the allowance, though of course an approximation, is intended to compensate you for the additional expenditure you will incur, even if there may well be a right to claim for certain specific expenses as well. Whereas the fee, it's very clear from the paperwork we've seen, the fee is intended, and yet it uses the language to remunerate you for your experience, skills and time.
Well,
so, at the moment, I don't understand what you're saying that no one does it for free. The ones who are only getting an allowance do it for free, don't they?
We take issue with that, my lord, because whilst an allowance is notionally for the cost of bringing up a child, firstly, it's that one puts in receipts for expenses for a whole range of things, and also it's taxed as income. And we say when looking at that in the round, it's more in line with a reward type
more
payment.
Complicated than that, isn't it? I thought the first 10,000 was there's something in the on the papers we've seen about the tax position.
Yes. You file your tax return, you get a 10,000 tax-free allowance, but
in respect of the allowances.
Up to a certain amount, yes. So suppose you're one of those foster carers that has the mixed fee, you don't know what represents what, you know you get the first particular chunk tax-free, and thereafter you set it out in your tax return. And certainly it would be an arbitrary distinction to say those who get the fees on top have a different character of a relationship than those with allowance.
Well, that I understand, but that cuts both ways.
We know from the evidence before us that many foster carers can't tell what is represented by what element of their payment. For your Lordship's reference, that's Supplementary Bundle 751 in State of the Nation. And there it says a third don't know which is which, and of the independent foster carers, 43% don't know which is which. And that point about the arbitrary distinction is reinforced even further in the light of what more we see from the reference given this afternoon, supplementary page 567, that most foster carers get fees, as almost all of those who work for the agencies do. So it seems to be unfortunate in the extreme if whether or not an employment relationship definition is satisfied depends on the fact that not all foster carers get a fee. And it's equally unsatisfactory if, as has been said throughout this hearing, the less you get paid, the less protection you get, even if what you really want to do in joining a trade union is to work collectively to get better pay. So in our submission, that not all foster carers receive a fee at the moment is not a basis for not granting them that status. We know they all get some payment, and looking at the way the ILO definition operates, in our submission, that's entirely sufficient. My Lord, there was reference to the clergy cases this afternoon, the distinctions between Church of Scotland and Methodist ministers and so on. Because those cases were decided not on an employment relationship basis, but whether there was a contract there or not, I don't believe I can be it's of assistance to consider those any further.
Yes, and you've certainly been entitled to say, well, even if some UK clergy aren't employees, the Good Shepherd case suggests, obviously, it all depends on their own facts, but suggests that the Strasbourg court might not look at it the same way.
No. Lastly, on employment relationship, we've checked the national minimum wage case law, and the way the term allowance is used there, we don't think there's of any assistance here. In that context, it's used as one component of a statutory formula for working out whether part of one's remuneration counts as the minimum wage or not, and which isn't a relevant consideration here.
No, well, probably now is not the right time to explore it. I think it's not wholly irrelevant in that it shows, but I think this is not an issue anyway. The concept of an allowance is something a bit different from remuneration. That's why you have to, as it were, take true allowances out of a national minimum wage calculation. But this is all rather tangential to the main point.
I believe it is, my Lord. And
yeah, no, well, that I
we had that situation in the big equal pay cases where allowances, of course, were basic pay.
It is sometimes a sham
for decades
term,
they've been separated off. So we just don't think it's
well,
going to help your
I doubt it would need to
analysis.
decide a case on that. So thank you for looking it up, though.
Turning to the question of other status, the point was raised this morning about whether a body can bring, or an association can bring, an Article 14 claim on behalf of its members. We say yes, the association can, if it's made up of members and is discriminated against because of the status of those members. There isn't a fully reasoned case on this issue in the bundle, but there are 3 cases where bodies brought Article 14 complaints to the Strasbourg court. In those cases was the claim rejected on the basis that the applicant was the body rather than an individual. So the best we can do with that is, firstly, Association X and Cleveland, which is a Swedish case. There, the issue of the status wasn't even considered, and the court went straight on to look at justification. For your Lordship's reference, authorities, tab 76, authorities bundle A2434 to 5 at paragraphs 55 to 56. And then the 2 Russian cases, one regarding the Salvation Army, one Church of Scientology. In both those cases, breaches of Article 11 were found, so the court didn't need to get to consider Article 14, but on the face of those judgments, there's no issue raised with the fact that the body has brought the claim. And my lords, for your reference, Salvation Army cases to tab 84, page A2636, and the second case, tab 85, A2662. And my learned friends will say a little more about the appropriate test shortly, but for the justification stage, we maintain that it's the ordinary fair balance test which is appropriate here, giving appropriate but not significant deference to the state. And it's wrong to say that we only said that the manifestly without reasonable foundation test had been certified in welfare benefits cases. Your Lordships may recall from my earlier submissions that we emphasised the allocation of resources.
Yes, I remember you saying that.
Thank you. I won't repeat myself on that point. So legitimate aim number one, it's interesting that Mr. Collins this afternoon stresses the interests of labour and management and the economic and social order. Yet when you look at the way legitimate aim is defined, below in the EAT and here, it's done on the basis of with and without contracts. Now, obviously, as I've said before, that distinction, the contract distinction, appears nowhere in Article 11.2. And our submission is that it clearly isn't a legitimate aim, an occupational classification, and Pastoral Selbun, Good Shepherd, and indeed Manole, the self-employed farmers, make that clear. And for your Lordship's reference, that's paragraph 143 of the Good Shepherd and paragraph 62 of Manole.
Did you say 63?
I'm so sorry, 62.
62.
I might have said 63.
No, I'm more likely
62.
I misheard. Okay.
And we just query what evidence has been put in to support that there is a rational link between the measure and the aim in question. Moving on to the issue of best interests. In terms of the time that has been taken going through these various reports and witness statements this afternoon, what is of most interest we submit is what is not in those surveys and reports. No cared for children who had foster carers who were trade union members were spoken to, or even asked, is your foster mum or dad in a trade union?
Do you mean any trade union or trade union at Quay Fosterer?
Any trade union.
Why would you ask? They might well, if they were teachers or something, and they might well be members of the NUT. But I mean,
well, that could have
why
been
would that be
asked.
relevant?
Because if they were there to do with their being a foster carer, that might be relevant to understand.
Oh,
How
I
does
see.
that
Well,
make
sorry,
you
that's the
feel?
very question I was asking. I may have
Well,
expressed it
if
badly.
they were in the one could be in the GMB for a whole number of
Well, quite.
professional reasons, but that's something you might want to pursue. If your foster parent was in a trade union to do with them being a foster parent,
Yeah.
then you might say to the child, how does that make you feel? Why do you think they're in that trade union? What do they want? Have you ever talked to them about what they want? And although this question might be a rather difficult one for any child to answer, do you know if your foster parent is in a listed trade union or not? Because that difference is entirely pertinent to the best interests question here. And whilst Mr. Collins says there's no problem in the Secretary of State's view for cared for children having foster carers who are minority members of trade unions such as the IWGB. It seems irrational to not mind about one, but say there's a risk to the best interests of another. And that simply hasn't been explained to you. Why should it make any difference? And therefore, when the conclusion is reached by the specialists in the report, it's simply not possible to see that that conclusion has any link to the particular being sought here. So where Neri says at supplementary bundle page 590, employment status would impinge drastically on the independence of foster carers, turning homes into places of work, we can see immediately that's nothing to do with being able to be a majority member of this trade union. Nothing at all. And in our submission, my lords, what those experts actually mean by saying impinge drastically on the independence of foster carers is far from clear, as is the assertion that it would turn homes into places of work. We say the homes remain the homes, the work is being done already. What we're seeking to do is to say, well, they always have had employment relationships. We ask this court to confirm that in order that they can have their trade union listed.
Whilst we're on that point, and maybe you're going to come to it, one of the things that I think troubles me is the way the EAT dealt with it, or didn't deal with it in paragraph 121. I still have difficulty understanding what their conclusion was on this very point, because they expressly say it's not possible to reach a conclusive view as to the merits or otherwise of the parties' respective position on that particular issue, which I understand to be the question as to the perception of the looked after child if the home was a workplace. I think, it's not entirely clear, but it's that lack of finding which I think the implications of it.
Well, in our submission, what that lack of finding equates to is that when carrying out the balancing test and looking at the proportionality analysis, the justification defence cannot be made out.
The respondents are probably right to say, because when you read it carefully, that they refer to all the evidence which was before the court, and that includes the fostering network, because I think Lord Hendy referred to it in. Yeah. But it's what they make of it, or what they do address from within those documents, and what they don't address.
Well, we can try to read between the lines, my lord, but it's very difficult. At the very least in our submission, it's an error of law, because it doesn't say in clear terms, I find this defence, I find that it's up to the mark, and it applies with the best interests.
So sorry. Yes. If that was the only problem, it could be resolved here.
The reason why that's not a concern for your lordships in our submission is this. If here we were looking at issues of annual leave, picketing, a whole range of rights, which, as my friends say, we ought to have brought all together, then I can absolutely see you would have concerns about letting that issue remain unresolved. But we're not dealing with any of those issues here. And as we accept, even when on another day we come to have those issues determined before the CAC or further, that's the time that the real exercise of looking at what falls on either side has got to be given a good shake and to see where the cards fall down. At this stage, the very fact that Neri knew there were foster carers in trade unions and didn't think it was necessary to go back and ask someone, find some children to ask how they feel about their foster carers being in the GMB. that wasn't the issue that he was concerned about. There were other kinds of rights. And because this is just the first stage, the threshold, and we accept we don't get everything else along with this, it doesn't matter that you don't know exactly what the EAT had determined at that stage, and that you can say justification is not made out. I'm very anxious of taking up too much time here. I think the only other point I was going to say is, in terms of the grain and your reading down exercise, we agree with my Lord Justice Green's comment, where he said the primary function of the 1992 Act was to address the inequality of bargaining power between employers and workers. You've got the employment relationship definition. That gives clarity, in particular in this reading down exercise. We don't believe there's a need to nail down a single form of words at this stage, because contrary to Mr. Cooper's submissions, you're not legislating here. You're dealing with a specific exercise pursuant to Section 3 of the Human Rights Act. In terms of what needs to happen with coming back for further submissions and declaration of incompatibility, we say you're able to read down, you don't need to make such a declaration. Thank you very much. I'll hand on to Lord
Henry. Yes, Lord Henry.
Lords, I'm going to try and avoid duplicating anything, but there's one or two points of amplification and two points of addition. Lord, first point I wish to address of the 5 I think I have is the employment relationship. The employment relationship is a necessary step for engagement of Article 11.1 or interference with Article 11.1. We agree with Ms. Krasnow that the Selborne case forms a good analogy with our own case, and we do emphasise, as she did, the case of Manole there, and she gave the reference to paragraph 62. Can I just emphasise that that's Authorities tab 95, page 2969, paragraph 62. The European Court in that case addressed the question of whether self-employed farmers who had no employers, no contracts with anybody, not paid by anybody other than their customers, whether they could form a trade union. And on the question of Article 11.1, they held that they could. And that's what paragraph 62 says. The paragraphs which Mr. Collins took you to are where the court addresses 11.2 and finds that in the circumstances of that particular case, there was no interference. There were other means by which their aims could be...
Well, hang on. 11.2 isn't about interference. 11.2 is about justification.
Yes.
You said there was no interference.
Sorry, did I? Oh,
yes.
It's been a long day, my lord.
Well,
they held that there was an interference in breach of Article 11.1 by not allowing self-employed farmers to register a trade union. But that interference was then justified under Article 11.2. It's an important case because it amplifies the reasoning in Selborne and puts it shows that Article 11.1 of the right to form and join trade unions goes in fact beyond employment relations. But we are content to leave it at employment relations with the indicia in Selborne. But there's one point that both Mr. Cooper and Mr. Collins put to your lordships in relation to the ILO recommendation 198, which they said was a definition of the employment relationship, and it could be summarised by reference to an irreducible minimum of work for reward, the work-wage bargain. Lords, I invite your lordships to look at 198 in toto. It's cited extensively in Selbach. But look at the whole thing. It's much, much more nuanced than that. It's Authorities tab 23, page 565, and paragraph 13, which is crucial, is at 568. Finally, in relation to employment relations, the issue which my Lord Justice Underhill addressed with Ms. Krasnow a moment ago, the question of remuneration. We make the point that this is the foster carers in this case are not merely reimbursed expenses; they are paid allowances and fees. I won't go further into that. But if your lordships look at some of the evidence to which Mr. Collins referred, the foster care network supplementary bundle, page 750 to 752, and the NARI report, pages 587 through to 589, lordships will see.
So what were the references in the foster care network?
Foster care network's supplementary bundle 750 to 752.
Thank you. And then, sorry.
And NARI is supplementary bundle 587 to 589. It's particularly instructive to look at 589, where a hypothetical example of a foster carer with 2 children, who they're called Malcolm, his income is set out there. It's the equivalent to somebody who's not a foster carer earning £54,000 a year. But our task is not to show that foster carers are well paid, quite the contrary. Lord, so that's the employment relationship. Something next on interference itself. Mr. Cooper's core point on which his arguments hinged yesterday is that this is all about listing, and listing is only relevant to the extent that it provides mere evidence of trade union status. But as the point has already been made by my learned friend, this is really all about Section 1 and the definition of a trade union. We agree with Mr. Cooper that when you analyse the array of rights which have been discussed in this case, on which Section 29, which are dependent on workers satisfying Section 296, there are, as he points out, different considerations on different facts with different hurdles and different consequences and different conditions to be fulfilled. But in our submission, that makes our case for us. The fact that there are different considerations in respect of consequent rights assists us in our challenge, as Ms. Krasnow emphasised a moment ago, which is simply that the certification officer was wrong not to list us by reason of his analysis of Section 1 of the Act. Lord, Mr. Cooper and indeed Ms. Krasnow illustrated their points by reference to Schedule A1, the recognition procedure. But 2 points about that. First of all, before we even get to the question of whether there's a certificate of independence, and long before any analysis of 10% membership, or whether the workers in the prospective bargaining unit are indeed workers or not, the first requirement is that the application has to be filed by a trade union. Paragraph 1, Schedule A1. But Mr. Cooper, in focusing on the right to collective bargaining, overlooked perhaps the essential element of, the most essential element of Article 11, which is the right to form and join trade unions for the protection of one's interests. And that's the right, primarily, that we seek to have applied in the instance case. Lords, as the argument developed, we thought it might be helpful to your lordships just to list together in one place the advantage that we detect in being a trade union. We point out that this is underlined by the fact that Parliament has provided a specific right of appeal against the refusal to list. That's section 9 of the Act. In the authorities, it's authority tab 2, page 46. The advantages that we detect are these 6. First of all,
if you want to give them, you'll have to slow down slightly if you want us to note them down.
Of course, my lord.
Yep.
First of all, it's a gateway to certification of independence, which in turn is a gateway to other rights. Secondly, it's a direct gateway to particular rights. For example, section 11, the restraint of trade section, section 20, limitation on damages in acts in contemplation or furtherance of a trade dispute. Thirdly, it prospectively confers a status which avoids future uncertainty.
Yep.
Fourthly, it's likely to avoid future challenge and litigation about its status, which could arise from third-party claims or claims against third parties, claims by members against employers, or members against the union itself. Fourthly or fifthly, I think, it confers, as my Lord Justice Green suggested in a question to my learned friend Mr. Cooper yesterday, it confers the stamp of respectability and makes clear that the entity is subject to the regulation of the regulator, in this case, the certification officer. And your Lordship's not been taken to all the powers of the certification officer, but I noted reference this morning to Schedule A3, which is powers of investigation initiated by the certification officer herself, which were conferred by the Trade Union Act 2016, in addition to claims by members against unions in relation to breaches of rules or amalgamations, mergers, and so forth. And finally, and conversely, a decision by the certification officer that an entity is not a trade union is bound to be damaging and will invite, at least as a first reaction, rejection by a judicial body of any claim reliant on proof that the entity is a trade union.
You mean a trade union capable of being listed?
Indeed, I'm sorry, shorthand, Lord, yes. So that's important. In this case, having failed to be listed, we're not just another entity which says it's a trade union. We're an entity which the certification officer has publicly refused to declare as a trade union under the statute, and that is damaging. Well, the fourth of my 5 points goes to justification under Article 11.2, reminding your lordships that the question here is whether the restriction fulfills a pressing social need. This, in our submission, is not an issue which falls within any broad margin of appreciation, either in European law or its UK equivalent breadth of discretion. We're not challenging the industrial relations system established in the United Kingdom or any specific part of it. What is in issue here is a very restricted question, is whether the restriction on the fact that we cannot be a trade union, not we, my learned friends, clients cannot be a trade union, is whether a trade union composed mainly of foster carers can be barred from constituting a trade union in UK law. That's the issue that has to be justified. And we make the point, as Ms. Krasnow did, particularly bearing in mind that if those foster carers were in a minority in their union, that is apparently acceptable, but not if they are in a majority. Now, Lord, the evidence in relation to the interests of a child simply doesn't address that issue. Miss Williston put in 2 witness statements in this case. The first is at page, the relevant passage is a supplementary bundle, page 25. The second is at 669. And those witness statements were put in on behalf of Mr. Collins' client, the Secretary of State for Education. They simply do not address the question.
Yep.
Lord, I invite your lordships to look briefly in the supplementary bundle at what Miss Williston says at page 25. I'm not.
As time is short,
Indeed.
as we've been there both with you and with others, and as Mr. Burton, maybe Mr. Burton will tell us he doesn't need to say anything, but I suspect he's not going to say that.
I'm sorry, my lord. I just invite your lordships to read the 2 paragraphs on page 25, yep. And they address employment rights. They do not address the trade union issue.
Yes.
And no evidence, we say, has been put before this court or the Employment Appeal Tribunal, and indeed the Employment Appeal Tribunal, did not address that specific question. Lord, I had a 5th point, but I'm going to abandon that in the interest of hearing Mr. Burton.
Yes,
That's
Mr. Burton, we might, if you want to come forward, I think you probably better come forward. Yes, quite apart from anything from live streaming points of view, you don't get caught from back there.
Well, while I'm getting into place, can I ask the court to turn up DA, which is benefit cap number 2.
Remind us what number it is. Tab. We will turn it up, but you must tell us which tab it is.
65.
65.
The submissions from my learned friends, Mr. Cooper and Mr. Collins, that I am going to try and address at the time I have available, is Mr. Cooper's submission about burden of proof, sort of known unknowns, if I can put it that way. And then I hope to say something a little bit about the evidence and the conclusions of the EAT. The first point will take a little bit of time to develop, but it is important because it goes to the very heart of, I think, the issue, which is what does the court do in circumstances where it finds there's a failure to comply with Article 3, and the evidence is therefore inconclusive on question of best interests. So if I can ask the court to just read paragraph 66, which is the paragraph that my learned friend, Mr. Cooper, took the court to, which he suggested shifted the burden of proof.
Did he take us to it?
He referred to it.
He referred to it, but didn't take us.
So the way he put this point was to say it would be unsatisfactory to decide this case in circumstances where there's inadequate evidence, but there might be a solution, which is because it's contended that the manifesting without reasonable foundation test applies, in fact the burden shifts to the appellant, and unless it can be demonstrated effectively positively that it would be in the best interest of children to allow listing, then the justification defence succeeds. Whereas, of course, the conventional analysis would be that if...
Yes, okay. Which is the paragraph you want us to read?
66.
Let me read it first.
Grateful.
reference in this context to burden of proof more theoretical than real.
Yes.
Yes.
And then there's the point about, well, what happens when you introduce Article 3 into the analysis? And that's paragraph 78, my lords, at page 2029. We looked at this briefly during the course of my submissions, but just reminding the court of what it says. Now, I admit, I concede that it doesn't, it's somewhat neutral as to burden in that paragraph, but it's clear that if there's non-compliance with Article 3 in relation to a foundation of the justification of defence, that foundation may fall away. And then it's instructive just to look at how Lord Wilson actually decided the issue at paragraph 87. If I could just ask the court to read that. Having conducted the inquiry, the court is satisfied that the two-stage process inherent in Article 3 was complied with by the Secretary of State or the government. And it was only because the court was clear about that that it was then, as it were, taking a hands-off approach to the question of whether or not the court should take a different view on the ultimate judgment reached. And then we see in the middle of paragraph 88, final conclusion, the appellants have not entered any substantial challenge, so I'm reading for the third sentence, to the government's belief that there are better long-term outcomes for children who live in households in which an adult works, which was the substance of their best interest finding. So ultimately, in my submission, it makes no difference whether the burden is on me to demonstrate that the government hasn't complied with Article 3, at least not in this case, in any event, because once it's clear that the public authority hasn't done so, then, according to paragraph 78, the ordinary conclusion would be the justification of defence is not made out. I accept a chink of light is left for the court to go on to proceed to determine the issue itself in lieu of the primary decision maker having done so, and I will come back to that in a second. But that's where we are on the question of burden and what conclusions the court should reach, if indeed the court is satisfied that there has been no best interest assessment here. And just on that, of course, we've heard from Mr. Collins this afternoon, and at no point did the Secretary of State make the submission that the Secretary of State has conducted any form of compliant best interest assessment, either in substance or in form. That's important in my submission.
Did he make that submission?
Well, he did, but he didn't make it. What he
Well,
did,
but he did make it. You just don't think it's good enough.
Did you make it?
I did.
Well,
Yeah.
well, I absolutely made it.
He made a submission which you think doesn't.
I'm most grateful. Well, to be with respect to my learned friend, obviously I'll deal with it if that's what it was intended to convey. I didn't understand it to say that, and that's not the argument that's put forward in the skeleton, for example.
I think it said that the evidence which was relied upon in substance addresses the issue.
But yes, I had understood that to be a submission in support of the EAT's judgment, but that's fine. It doesn't make any difference to what I want to say, ultimately. And just on this point, though, or just to finish the point about burden and relief, is it really so unsatisfactory that the court would have to find the justification defence is not made out if there's been no best interest compliant assessment, and therefore the court can't reach its own conclusion? And in my submission, it wouldn't be. One, as a matter of legal principle, this isn't just about the administration of justice. This is about the state interfering with rights. And if the state's interfering with rights, it needs to be able to positively justify that. That's why the burden is there. And second, of course, we are dealing here with the very important component of the rights of the child, and they are rights, and it is a right to have a best interest assessment done for the obvious reason that children are not participants in any of this. They're not parties. They're not in a position to advance their interests. So if other people are making decisions about what's in their best interest, then they need to be able to do it pursuant to procedural guarantees as is set out in the general comment and have now been endorsed by the Supreme Court on 3 occasions. And that is the reason why ECRU is intervening. It's to uphold that key principle. You're going to make decisions about your children and profess to be acting in their best interest. You must abide by those procedural guarantees. My learned friend says, well, in fact, the law is not quite so clear-cut on this in relation to the procedural component of the best interests duty. I say that's wrong. The references being Lord Wilson in the Matheson case, which is tab 41, page 1571, where he makes it very clear that if you haven't complied with the procedural obligation, then you cannot comply with the substantive one. You cannot treat the best interests as a primary consideration if you haven't properly determined what they are in the first place. And the reference that my learned friend sought to rely upon was paragraph 116 of the judgment of Lord Justice Leggett in the SC case, which, in the interest of time, I'm not going to take the court to. I'm just going to point out this, that predates the decision in DA. And DA, of course, is the decision that's binding on this court. And just for good measure, Mr. Justice J, in the PRCB case behind tab 70, at paragraphs 96 and 97, acknowledges that DA postdates SC and says that the more stringent test adopted by Lord Wilson is the one to be preferred insofar as there's any difference. My Lords, then, I was going to say just very quickly, of course, Lord Wilson leaves open a chink of light, I would say, in paragraph 78, that a court could go on to determine a question of best interest itself, even if satisfied there's been a failure with the procedural component of the Article 3 duty. And I've already spelt out why there are perhaps reasons why the court might, as a question of law, be reluctant to do that, and I've already said there are no examples of the court ever having done that. But can I just reference footnote 8 of my submissions, page 255, which is the well-known Court of Appeal case of the Queen on the application of Elias versus Secretary of State for Defence, paragraphs 833 and 858, which go on to explain just how difficult it is for a court to do that, where there are deficiencies in the evidence. And one of the practical problems of not considering these issues before you come to court is you leave the court's hands tied. And I would just ask the court to have those comments in mind. And then finally, in any event, of course, the EAT didn't do its own assessment. It says as much in terms. And my Lord Justice Green has already identified that in paragraphs 48 and 121, it expressly disavows any attempt to reach a conclusion on the issue between the parties, even the narrow issue about whether or not foster care is being perceived as having worker status would be in some way detrimental to the relationship between children and their foster carers. And I have just a couple more quick points to make, if I may. On the evidence, please be reminded that being keenly aware of children and children's interests even is not enough. It's not enough to say, look at the size of these reports. They're all designed to try and think and look after children. That doesn't demonstrate adherence to children's rights. And I'm using that word keenly aware because that was the words used by Lord Carnworth and Lady Hale in the SG case, which is tab A47, paragraphs 109 and paragraphs 225. And I would invite the court to look at that case closely, as I said yesterday, just to see just how the court really does
Sorry,
approach.
well, give us the reference again.
Sorry.
Lord Carnworth and Lady Hale.
109, Lord Carnworth and Lady Hale, paragraph 225.
Which case, though?
Sorry, that's SG, benefit cap number 1,
SG, okay.
which is behind A47.
Yeah, thank you.
My Lords, I think you have the point about what is said by everybody on the appellant side about the deficiencies of those reports anyway, insofar as being material that the Secretary of State can rely on to address justification in this case, because they were looking at a different issue.
Yeah.
Certainly a broader set of issues at the very most. But it's more fundamental than that. My Lord Justice Bean put it to me yesterday, well, has anybody actually tried to balance what might be the positive outcomes for children of unionisation, leading to better pay conditions, leading to more foster carers being available, as against the adverse consequences around the issue of perception? And the simple answer to that is no, they haven't. And nothing in those reports gets anywhere close to doing that in my submission. And then just finally, then moving on to the EAT. The EAT at paragraph 79 and 116 does appear to understand that. It is,
just give me those paragraphs.
Sorry, 79 and 116. The EAT appears to understand that it's got to focus on what the impugned measure is and ask the question whether or not the consequences of not listing are such as to protect the best interests of children. But if I may say so, some of that discipline seems to be lost when they move from the question of interference to the question of justification. You can't, on the one hand, say very narrowly, well, the interference is not necessarily all that serious, only concerns this narrow right about mandatory collective bargaining, and then when you move to justification, start saying, oh, well, this is now going to be the full set of issues that are raised by the Secretary of State and are even discussed in the reports that attach to full employment status. And it's worth reminding the court in my submission that of the 4 reasons that the Secretary of State pleaded as to why, if this appeal were to be allowed, that would be detrimental to the interest of children, only one of those, which is the one about perception, was the subject of some sort of positive finding by the EAT. The others were not. There were no findings about reorganisation in the care system, no findings about fundamental undermining of the relationship between the foster carer and the child, or indeed some significant loss of independence on the part of foster carers.
Doesn't sound like a reply point, Mr. Burton.
Well, I apologise, but the reason I'm making that is my learned friend did rather weakly try to reintroduce again this idea of industrial action being the problem and picketing. But the EAT positively found that that was extremely unlikely. You can't have it both ways. So my final point really is about the EAT and this point about perception. We've heard that, of course, the opinions of Neri and others are important. But one page I don't think we did look at, and I wonder if the court can just look at it, because it goes directly to the point that my learned friend is raising, is at page 555 in the bundle.
Supplementary.
I do apologise, supplementary bundle, yes.
Yeah.
So there Neri is saying very clearly and in terms that he and his co-authors were very clear that there is no conflict between being a caring or loving foster care and being adequately compensated. And then goes on to talk about the apparent shyness about sort of coming forward in that regard.
Sorry, where are we? 555, which part?
Under financial compensation and reward of foster carers.
Oh, I see, sorry, yes. Right.
Third or page 12.
Thank you. Yep.
And to some extent that is reinforced by a decision of the court, this court, which is behind tab 40, behind tab 71, page 2272.
Sorry, I got. Where are we going now?
So we're going to the case. If I could ask the court to turn up page 2272. Get the right paragraph. That's authorities bundle. I apologise.
This is a new case.
It is, but I wasn't really given the time to make my 7 points about the EAT's conclusions, but my learned friend was sort of replying to them. So I was just making sure.
Okay, well, that's all right. Yep. Okay.
Anyway, the paragraph is there. And it basically reinforces this point that there's no inconsistency.
But which paragraph?
Paragraph 48.
It can't be paragraph 48. It stops
39.
39?
I do apologise.
39 is the side.
Yes.
Okay, just give us a moment. Well, that's
It's a slightly
interesting. I don't
different
quite
context.
see why it's relevant.
My lords, I'm just trying to make good the proposition that even the courts have recognised that there's no fundamental inconsistency in the context of foster care between familial life and the commercial nature of the relationship, which seems to be the gist, really, of the perception argument that's been.
Well, I'm not sure about that, but
It's that
in case it was, that's what your answer would
yeah,
be.
yeah.
Right.
Yeah, and you know that brings the final point really here, which is that the balancing exercise that has never really properly been conducted is, on the one hand, the positive impacts that might be a consequence of compulsory collective bargaining against the perceptions formed by children.
Quoting my lord making. Yes. Thank you very much indeed, Mr. Mr. Burton.
Thank you.
My Lord, you asked me two questions which I never answered. Do you want the answers or has the moment passed?
Well, I don't know what they are.
Just two factual points. My Lord asked whether there was a legal definition of long-term
long-term,
foster
yes.
care. And I'm told the answer is that it's in Regulation 2 of the Care Planning, Placement and Care Review England Regulations 2010.
Is that in our bundle?
No,
Could someone send it to us?
we will.
I don't know in the end whether it will be relevant, but it would be nice to have it. Thank you.
The other question my Lord asked was about how the figures for allowances are set, and there's some information about that. 40 of Miss Willison's statement, supplementary bundle, page 22.
Thank you very much indeed.
My Lord, can I correct something I said to your lordships earlier with too much confidence about case management in the EAT?
Yes.
I'm reminded that Mrs. Justice similar as she then was, listed for a final hearing. That hearing was actually converted to a case management hearing where we talked about interviews.
Thank you very much indeed. I think I must have picked that up somewhere, as I wouldn't have raised it otherwise, but thank you.
There were then other case management hearings prior to our long final EAT hearing.
Thank you very much indeed. Well, that's useful in the interest of accuracy. Thank you, everyone, both those who have spoken and those who haven't, and of those who haven't, those who are not even in court. I think I speak for all of us in saying the quality of the written and oral submissions has been high, and we've been very much assisted by it. We are, of course, reserving our judgments. Drafts will be circulated to Council in the usual way for correction of typographical and other minor factual errors, and so as to enable the parties in terms of consequential orders. And in this case, depending where it goes, there may also be room for further substantive submissions about relief. We are likely to indicate whether we want those, and those will either be determined on paper, or if it is necessary, there will be a short further oral hearing, realistically, obviously, in the new year. Sorry, that gives you the indication that you may get the judgment itself before the new year. I wouldn't hold your breath. Thank you all very much, and we'll now rise.